going to be moderating a little bit, and I'm going to also begin as well. And so last time, if you joined us, I talked a little bit about what Medicaid planning is. Basically, we can take anyone who's over the age of 65, regardless of their income and assets, and qualify them for Medicaid to pay for their long-term care expenses, their medical bills, their prescriptions. We also talked about estate planning and the status of remote online notarization. So what I'll do is after this, I'm going to post both the replay of this webinar, and I'm also going to post the replay of the last webinar because I don't want to redress the same exact issues. Today, what I want to focus on is, of course, we're living in this quarantine coronavirus world, and I think we're now past the point where people understand that this is real. In terms of myself, I have an uncle who tested positive for coronavirus, and he's very lucky. He was 72 years old. He is 72 years old and had a very mild form of it. And what's interesting is I also know, in fact, Danny Lavin and Dan Sarfati and I grew up with a guy who's in his mid to late 30s, and he came down with a severe case of it. Was in the ICU for 3 weeks, on the ventilator, the whole long bit. Thank God he is now back home with his wife and young child and recovering nicely. But he's still not out of the woods. He still has to have oxygen. So we have very, very young people, people of all age ranges being affected by this. Why do I bring that up? I bring that up because I now have more and more clients on the estate and incapacity planning side, interested in making sure they have an updated estate plan, but more importantly, their incapacity planning. What if I'm unable to make medical decisions for myself? Who gets to do that? What if, God forbid, we reach the point where at the end of life, what do I want to do? And what I'm going to be focused on specifically today is what's referred to as the living will. And very briefly, the living will is not the same as the last will and testament. The last will is who gets your stuff after you pass away. That's not what I'm talking about. I'm talking about the living will. The living will is one of several advanced healthcare directives that basically says if you are incapacitated and your treating physician and one other consulting physician believes that you are in an end stage condition, a terminal condition, or in a persistent vegetative state with no medical probability of coming out of that condition, then you are typically expressing your desire to be let go painlessly and not to be artificially kept alive. You can have your healthcare surrogate also be designated as sort of the overseer of that. So you can have your doctor, the two doctors, and your healthcare surrogate all agree, yeah, we don't think that the patient's coming out of this, and let them go painlessly. Don't keep them artificially breathing. Don't keep them on dialysis. Don't treat the infection. That's how a lot of people want to go, for good reason, because the end of life can be a very painful experience, and that's not how most people want to leave this world. However, I bring this up today very specifically because in this coronavirus world that we're living in, most living wills, in fact, I would venture to say nearly all of them, have language that's either ambiguous or very specifically says, I never want to be put on a ventilator. I never want to be kept artificially breathing. As we know with coronavirus, that's what it affects, right? People are being put on ventilators. And in this world where ventilators are being rationed, right? All we hear about in the news is how there's not enough ventilators to go around. The fear, I think, is that with a standard living will, if doctors see that you never want to be put on a ventilator, are they going to take that ventilator away from you and give it to someone else who hasn't made such a designation? So this is really serious stuff, because not being put on a ventilator can mean the difference between life and death. Now, legally speaking, especially someone who's relatively young, just because they're put on a ventilator, it does not mean that they should invoke the living will. The living will is only if you're incapacitated, only if the doctors believe you have no reasonable likelihood of coming out. So strictly legally speaking, the living will should not be invoked in a COVID-19 coronavirus situation. But the fear is, if you're rationing ventilators, are doctors going to read that document liberally and say, okay, this person doesn't want to be on a ventilator, we're going to give it to somebody else? And quite honestly, I don't know the answer to that question. I think that doctors are under a lot of stress right now. I think that given this pandemic and they're feeling overwhelmed, and again, we're just talking about fear and making people a little bit more comfortable with the documents that they have. What I'm doing with my living will documents is I'm adding in very specific COVID-19 coronavirus language that says, if I am put on a ventilator, or if I am diagnosed or it's believed that I have a coronavirus or coronavirus-like condition, I want the ventilator. And don't take me off the ventilator unless I've been on the ventilator for a certain period of time and it is eminently apparent that there's no way I'm coming out of this thing alive. It's a hard conversation to have with people, but I'm having a lot of prior clients come to me who we didn't think about this pandemic, and we're redoing that document to address those concerns. There's a couple other concerns that I am addressing in my healthcare surrogate and living will documents, which is your healthcare surrogate, the person who usually is empowered to make decisions for you if you're unable to do it yourself and you can't orally or physically express your wishes. That person now can't visit you in the hospital, right? Because we're quarantined, they're not letting in people. So I'm also adding language that basically says you doctor are specifically authorized to talk to my healthcare surrogate through Zoom, over the internet, over the phone, through any means necessary, even if it's not in the physical presence. And doctor, I'm holding you harmless for relying on those in-person communications. So we're adding that language as well. So I know it's a lot to digest and there's a lot to talk about with regards to what needs to be in healthcare surrogate designations and living wills. The last thing I'll say is the 3 forms that you see being circulated that pertain to living wills are very, very generic. And I don't think that this is a generic sort of situation. You want to go through all the different artificial medical procedures and talk to your lawyer about whether you want this, and if you do, for how long. And these are the conversations you need to have with your estate planning attorney. And if I can be of service, please. But again, it doesn't have to be me. Any estate planning or elder law attorney is equipped to have this conversation with you, I would hope. So with that being said, I now want to talk about some other non-estate planning related topics of concern. Basically, just to remind you what we've done, we're now going to be talking to Danny Lav.